Alex here with part 131 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We left off in the previous video with, I believe, an order denying, and the video before that was my motion, more specifically my omnibus motion, and this is a video that's going to go over my ex's opposition to motion. I can't really recall my mindset at the time, and I'm not sure it would have been much better or much worse than the way that I felt following the last hearing. Probably at this point in time, I could even speculate that it tapered off, given the fact that I'm still filing things, even though the court's upset about it. So I suppose that at this point in time, we should really just go straight into what my ex's attorney has filed. Here we have my ex's attorney's omnibus motion, opposition to omnibus motion to reduce arrearages to a judgment, for an order to show cause, to modify timeshare, for an order to email vacation requests, and for an order restricting certain legal representations. We go into the first paragraph. Standard introductory paragraph is my ex's attorney introducing herself as my ex's lawyer and indicating to the court that she files in opposition to my motion. Points and authorities. First thing she mentioned, so it doesn't look like she mentioned, okay, hold on a second. Usually you'll see a factual background first followed by an argument, but it looks like instead she's going to do it issue by issue and probably break down the facts and the law in those specific areas. We'll see. Maybe there's this a lower section that has the argument separate. So first she goes into child support, February 8th, 2013. She mentions the court's order requiring payment of attorney fees rather than pay fees. Unilaterally opted to credit her for the amount owing, instructing her that she could pay an offset. I'm not sure what she's complaining about here. Okay, so this is her complaining that my ex... Okay, so what's going on here is my ex owed me money for child support. So I gave her the money that the court ordered way back when regarding the award of attorney fees, minus the amount of child support that she owed. And so she's complaining here about that. Apparently she wanted me to pay my ex the full amount despite the fact that my ex owed me money. Okay, this is ridiculous. Anyone in their right mind doesn't have to be an attorney to know that if they owe their friend $150, but if their friend owes them $50, then they don't give their friend $150 and wait around for the other 50. They just subtract the 50 from the 150 and give them 100. This is super simple stuff that any ordinary person knows. I don't even know why she put this in this brief. If you want to know more about what I'm talking about, please watch my video, set-offs and offsets. It's just silly to see this here. Anyway, let's go ahead and go down into the medical payments section. The law states that parents have to provide health coverage for the child. This is okay. This is known. In my motion, I request payment for a dental surgery on July 22nd. I told my ex that my wife's dental insurance would possibly cover the dental surgery. Okay, I again emailed my ex regarding the dental procedure. My ex replied that I never got back to her regarding my wife's insurance and that because her insurance didn't cover the procedure, she could not agree to it. Is this lawyer seriously going to play that card? I mean, would she do that if, I hate to say it, but would she do that if her client was a male? She's basically, I mean, this is a crazy argument. Okay, when kids need surgery, you can't just say, I don't agree to it, therefore you have to pay the whole amount. I think this is another thing that everyone knows. This is... Okay, so this is what it is here, guys. I mean, I'm not going to go through the nitty-gritty here, but she's citing all of these arguments back and forth, and she's basically saying that since my ex did not agree to the surgery, that I have to pay the entire surgery. and there's also things in here that are argumentative. So she's bringing up stuff about leaving our son with a babysitter the day after a surgery, contempt of court threats. How is this relevant to the child needing this surgery? The lawyer is basically regurgitating my ex's arguments. She's gone full-blown 100% mercenary, which is she really doesn't care. She'll just say whatever my ex is going to say. I can't imagine that this was my ex's attorney's idea, that this was her defense to this. So anyway, this is just a back and forth argument about not agreeing and all this other stuff about being threatened with contempt of court. So if either parent goes outside the healthcare network coverage, then he or she will be responsible for the total amount. This is just playing dirty. It's not going to work because that's not actually what the court order says. See how it says here? This is the part that she didn't put bold. See this part here? She bolded this portion here, but she ignores the prior sentence. Both parties are to utilize the in-network healthcare providers for the child's healthcare needs. And then she goes into this other section that if you don't do that, you have to pay the whole amount. First of all, this specific surgery and this specific dentist is in network. There are portions of the surgery which are out of network, but the surgery itself and the dentist herself, those are in network. Certain portions of the surgery are out of network, but it's not even really out of network. That's not a good phrase to use. It's more like it's just not covered. It's not that it's out of network. It's that this particular part of the surgery, for whatever reason, you just have to pay the full amount. So she's trying to make it look like I am violating the court's order by going to an out-of-network provider. But what's actually going on is I'm going to an in-network provider, and that just certain portions of it you just can't get covered 100%. So this is another thing that doesn't make any sense. This is like almost Twilight Zone level lawyering here. It's crazy to see this. So anyways, guys, this comes up at the hearing, and you're going to see that my ex gets squashed by the judge on it. But for whatever reason, the attorney wants to put her name on this argument. Okay. Guys, like, how does this not scream worst interest of the child? It's like, basically, they're trying to make me look like the bad guy by saying that I'm trying to get my son taken care of and I have to pay the entire amount of everything. And if I don't like it, then somehow I'm a bad person because of this other provision in the court order that says that I have to go and get in-network care. You can't even it's wrong in so many ways, because I just mentioned earlier that it's not really a debate about in-network versus out-of-network care. So it's like the arguments from the attorney are getting crazier and crazier as the case goes on. I remember the earlier portions of the My Docket series, I had a lot of respect for my ex's attorney, and I had recollections of moments in time when my ex's attorney actually helped me get things done. And now I'm at this point in the process where I'm starting to question that, because my ex's attorney is just getting nuttier and nuttier. Unless, as I mentioned earlier, she really doesn't want to put forth these arguments, but my ex, for some reason or somehow, is twisting her arm into getting her to put forth these arguments, which is possible. It is entirely possible that my ex's attorney recommended she didn't do this, but for whatever reason, when my ex put her foot down, she went ahead and, did it and then signed it. So anyway, let's go ahead and continue on. Next section here. While I attached numerous bills to my exhibits, my ex has no recollection that she ever received an explanation of Why is she bringing this up? Okay, this was specifically discussed in the previous hearing. At the very end of the hearing, if any of you have seen the hearing, you'll remember that I told the judge, Your Honor, my ex is insisting on explanations of benefits, but I don't get these. They get mailed directly to her. And I asked the court, is a bill enough? And the court said, yes, a bill is enough. If you're not getting the EOBs, you don't have to send the EOBs because you're not getting the EOBs. It's just, I think I have a video where I talk about this insanity. The video is called They Will Never Say Good Things. And I explain in that video that typically with win-at-all-cost lawyers and high-conflict exes, if you get to a point where you have pretty much an airtight case, they won't cave. What they'll do is they'll come up with the most inane, ridiculous defense that they possibly can. Rather than say, hey, we don't have a defense, he's right, let's just do this, they will come up with something, no matter how insane or crazy it sounds. And this is just that argument right here, which is, I'm not even sure if it's insane, it's just completely against what the judge said in the prior hearing. If anyone wants to watch that video, I think it's part 129 of the My Docket series. Don't quote me on that. In fact, I'm probably wrong and somebody's going to mention in the comments below, but vaguely that number is jumping out at me, 129. Anyway, at the end of the hearing, you'll see that this was settled by the judge. And in fact, it's probably even in the court order. But either they have amnesia or they're just trying to pull a fast one or the other. Next assertion here is that while I'm requesting reimbursement for the cleaning, my ex would note that the amount I list on Exhibit 7 for the cleaning is different than the amount listed as the previous balance in the dentistry for kids bill. The cleaning was also not covered by the insurance because her son had already had a dental cleaning the month before because she aborted the surgery. Oh, you know what? I'm going to let this speak for itself because she brings this up at the motion to modify and she gets destroyed over it. So let's just let you guys watch that hearing. It's not even the next hearing. I think it's the one after the next hearing. By the way, I know I talked about that in I think it's 2 or 3 videos back. There is a hearing video coming up. Again, it's not the one that goes over this specific topic, but it is coming up, and I thought it was going to be this video. In reality, I recalculated. I took a look at the dates and times on some of these filings, and it looks like the hearing video that's coming up is actually going to be 3 videos away from this video. So that should be exactly, we should be seeing 2 more videos of paperwork, and then the video after that should be the hearing video. So keep an eye out for that. We will premiere that video. And then here she just reiterates that she never agreed with the dental surgery, and therefore I need to, what is it? I incurred needless expenses because I refused to wait for coverage. The needless expenses were incurred because the procedure was aborted, because she walked into the surgery room and got it aborted. This is just, hopefully people are starting to realize why this case went to a termination of parental rights. We aren't even really 50% of the way through all of the craziness. We're going to see another good 50% of craziness beyond this point in time. And at that point, I think everyone will have a full picture as to how and why this case went as far as it went. Anyway, she's asking me to pay the full bill shamelessly. Next assertion here, modification of timeshare. The district court determines that the custody of a minor child, when the district court's going to make this determination, the sole consideration is the best interest of the child. She cites the law. She goes through this case here, which we've gone over probably 20 times by now. Modification of physical custody is warranted only when there's been a substantial change of circumstances. Okay, this lawyer is wrong here. I finally found out years later that the lawyer was using law that wasn't even correct. And I didn't know at the time, so I just kind of went with it. This in Nevada does not apply if you have joint physical custody. And the Supreme Court has stated this repeatedly. So she either knows this and she's exploiting the judge's lack of knowledge on it, or she just doesn't know how it works. She's guessing incorrectly that this is how it works. I talk about this in the video Change of Circumstances. Take a look at that video. In some states, you have to show a change of circumstances anytime. In Nevada, you don't have to. You only have to show a change of circumstances if one of the parents has primary physical custody. The reason why is because the law says so, and I explain the details of that statute in the video Change of Circumstances. Definitely take a look at it. But I will let my viewers know at this point in time that this assertion here that I have to show a change of circumstances is wrong, and that is not the law in Nevada. Anyway, I should say that I kind of did show a change of circumstances. His teeth are literally rotting out of his skull. 5 crowns, 2 extractions, guys. Next assertion is, I propose that it's in my son's best interest that the present schedule be changed to week on, week off. We've talked about this till, we're blue in the face. This is what's going to reduce conflict. Week off, week on schedule, week on, week off, whatever you want to call it, is going to minimize the exchanges, and therefore we won't see each other as much. Therefore, as I mentioned, less conflict. And it's not even my idea only, it's also the judge's idea. He's mentioned it at least 3 times, and I'm not sure, maybe even 4 or 5. And each and every single time my ex opposes it. So she's doing the same thing here. She doesn't want week on, week off. She says I'm a scary person. She says I show up late to exchanges. She says exchanges cause her stress, that they're stressful, and she sends designees. And yet, she doesn't want to go week on, week off. She wants to keep the exchanges at a maximum. I've talked about this in a number of videos before. The high conflict ex wants conflict. They will find reasons to increase the conflict, and they won't say that to the court. They won't say, hey, Your Honor, I don't want to go week on, week off, because if you do that, I won't be able to fight him as much. If they say that, the judge is going to look at them like they're crazy. So they will come up with plausible explanations as to why they want to maintain certain things in a court case. Typically, they'll say something like, I want to see my child as much as possible. They'll find things to say that make it plausible to the court that what they're saying is actually a good faith motive for the position they're taking, when in reality they are concerned that if they lose on that issue, that the conflict in the case will go down, and that the filings will go down, and that the child will actually be better off. I talk about all of these things in that video. I think it's called narcissistic pretexting. But in any event, I might also talk about it in the video. 3 stages of conflict. That might be another video where I talk about that. Anyway, let's go ahead and go down into the next section here. Our child is in 1st grade. It benefits him to see the parents on more than a week on, week off schedule. That's a very deceptive statement, because the child would get to see us the same amount. The only difference is the intervals. The next assertion here is that my proposal does not meet the prong of LSV Carucci. So this ended up being false. I already told you guys that this law does not apply because we don't have primary physical custody visitation situation. We have joint physical custody situation. Email vacation requests. Some time ago, I requested certified notification of vacations. I didn't request this. My ex requested this. So she's stuffing this in my mouth. This is annoying. This was my ex's request, not mine. I just wanted emails. In any event, my ex is saying that she stipulated to the change and she has no objection to an email notification rather than certified email, especially since we have already been using that method of communication. Yay! So there's one thing that she does not oppose, which is surprising, because this would make it difficult for her to lie. So I'm surprised she's going to go ahead and agree to that. Communication with third parties. My request has its unilateral plans to take our son to a doctor were hindered by my inadequate planning. Okay, so she's trying to say, what? I don't know how this is relevant to this point. Let's just go ahead and move on. Without the required 14-day notice to my ex, I chose to schedule a dental appointment on her day. Okay, so she's basically going to take that stand, that since the appointment was scheduled on my ex's day without her approval, what is this though? What's the point of this? Had I given my ex 14 days notice, there wasn't 14 days notice available. And then the thing that's even more annoying here is that at the previous hearing, she discussed the problem with urgent issues and not being able to come up with 14 days notice when there are urgent issues in these cases. So now she's throwing in my face the same thing that she said I shouldn't have thrown in her face back in that hearing. So we got hypocrisy and we got inconsistent positions. This isn't really a relevant point to bring up judicial estoppel, I don't think. But if you want to learn more about why attorneys raise inconsistent positions and what you can do about it, take a look at my video, Judicial Estoppel. It's also called the Estoppel of Inconsistent Positions. Moving into the next assertion, my ex arrived at the school and informed the principal that it was her custodial day and she was at the school. Oh my gosh, she's actually admitting this? Hold on a second. She was at the school because I may try to come to the school and take the child to the appointment. She's admitting this. The principal looked in our son's school file and discovered custody orders, which I had given the school, which confirmed that it was my ex's custodial day. I arrived at the school. I waited in the parking lot. I called the school from the parking lot. I had no time, went into the school office where my ex and the principal were conversing. Because I did not enter the office, I have no personal knowledge of the conversation, but she's not denying it. So it's true. So she's okay. So she's saying that since I didn't go in, I couldn't possibly know because I didn't observe it personally. She's dodging my assertion, which is I was told by the school that she threatened them with legal action. This is the kind of, I don't know if it's even doublespeak, but basically my ex's attorney is engaging in the same deceptive speech patterns that my ex does. So if you look at this, she doesn't deny it. She doesn't deny having threatened the school with legal action because she knows if one of those people showed up and testified on the stand, they would say, yes, she was threatening them either with contempt of court or some other lawsuit of some sort. So this is a way for her to say, hey, Alex doesn't really know what happened, but at the same time, she's not denying it. So that way she has a path of retreat. I talk about this in a number of videos. I think 2 videos. Facts versus lies might be one of them, and the other one is anticipating the response. I'm pretty sure those are the 2 videos where I explain how a high conflict ex will cautiously assert things in a way where they are being deceptive, but if they are called out, they will have a path of retreat. So for example, if I said, hey, Your Honor, she's saying that this isn't true, she would say, no, that's not true. If you look at what I said, all I said was that he didn't come in there, so he didn't hear it for himself. I didn't say that that didn't happen. So this is the type of stuff that you'll see. If you see stuff like this, guys, it's a red flag that you're on the right track. In any event, this is also, it's a silly assertion to make an emotion because it's insinuating hearsay, but hearsay is a defense. It's an evidentiary defense, and motions are not evidence. Assertions made in motions, allegations made in motions are not evidence. So to say that something is hearsay on opposition like this, even though I don't think she uses the word hearsay, it doesn't look like she does. So to say that it's not hearsay isn't really relevant, even if she's not using the label, because we're not really in court at an evidentiary hearing yet anyway. This is just me trying to show that there is a basis for an evidentiary hearing. I'm going to go ahead and move on into the next section. My ex is saying that my request regarding third-party communication would infringe on her First Amendment right to freedom of speech. So she's saying that she has a right to threaten the school with legal action to block me from going in there to taking our child to an appointment. So, it's starting to become more and more clear to me why what happened at the evidentiary hearing happened. And I mean, as I go through this document, I can just see why she was steamrolled at that hearing. Again, guys, it's not the next hearing, it's the hearing after that. So don't get too excited about the hearing coming up. It's a good hearing. I do win that hearing, but it's not going to be the one where the court goes over all these issues. She's saying that I failed to provide authority for the request. Not really. I mean, that's under best interest of the child. So I mean, that's not really a fail to cite authority. It's just the best interest factors. Next assertion here is, for these reasons, my ex would request that the court deny my motion, and that's basically it. Let's go into the next section. Declaration of my ex, which is swearing under penalty of perjury that all of the facts asserted in her opposition are true and correct. She signs it here. Certificate of service by mailing under Rule 5, indicating that this document was mailed to me. We have the motion opposition notice. If you go and check into the check marks, you will see that my ex's attorney had to pay a filing fee to file this opposition. Okay, index of exhibits. We have 1, 2, 3, 4, 5, 6. It looks like 8 of these exhibits it looks like 7 of these exhibits are new, and we will be going over those exhibits. 2 of these are references to an order that's already been entered by the court, so we will go ahead and skip over those, as is our policy in the My Docket series. We don't go over documents more than once in the My Docket series, and you can always go down into the description below, click on the links, download the document for yourself, scroll through it, and if you see something that jumps out at you, if you have any questions, go ahead and post them down in the comments below. I'm going to go ahead and move on. Exhibit 1. This is an acknowledgement of receipt of child support payment. I don't know what's relevant about this, but it's just saying that I acknowledge receiving child support. Exhibit 2. Maybe she paid child support after getting this motion. It's possible. That might have been what happened. She might have got my motion and then had me come in and collect a check for all the child support. That might have been why she, put that in there. We have here an email. Looks like this is my ex's email. So this looks like me communicating to her. It looks like worst case scenario, our son's dental is going to be $6,800. My ex's insurance covers, if it covers him, which it should, we can shave that down to $4,800. If her medical also covers it, we can hopefully get it down to a tiny amount. Either way, I'm able to make good on my half by mid-August. What about you? Exhibit 3. By the way, guys, I want to stop for a second. You'll notice how she agreed to pay before my wife's ability to put him on insurance even came into the picture. So if she was already agreeing to pay half, why is she using as a basis something that I brought up after the agreement to try and get out of her paying half? The reason why is explained in my video, Exploiting Good Faith. When you are a hammer, everything you see is a nail. That's how the high conflict X operates. And so she doesn't really care that it doesn't make any sense time-wise, that it doesn't make any sense, logically or rationally. She is just looking for any reason that she can find to justify the fact that she's going to renege on paying half of the amount. So even though I, in good faith, was offering to get our son on my wife's insurance, she doesn't care that it's good faith. She's going to exploit it. Again, the title of that video is Exploiting Good Faith. It explains how the things that you do to try and help above and beyond, that you don't really have to do, but you're just trying to be a good person, they will weaponize those things and use them against you. They're very shameless about this. They will not hesitate to do it. Please watch that video. So here she says that she is thinking of getting him an appointment ASAP by paying the whole thing Oh no, that's what I'm saying to her. So I'm saying that I'm thinking of getting an appointment ASAP by paying the whole thing and just having her pay me back. Have you managed to save anything up for this yet? I don't think she responds to this either. She says she'll be getting insurance in January that will enable her to afford it. Okay, this is, I don't know how I dealt with this problem, but I think the way that I treated this was her basically trying to drag her feet and giving me the runaround. I really didn't think that this was a sincere issue at all anyway. I thought she was just trying to buy time and disrupt the appointment again. Exhibit 4. Okay, on Monday, September 6th. Okay, don't threaten, can't afford it. Wait, hold on. Let's start from the timeline. Start from the bottom. Start from the bottom. Okay, here we go. You haven't regarded. Wait, this is. Okay, from me to her. You haven't responded regarding his pre-op. So I schedule. Okay, so this is me saying that I scheduled a pre-op myself. He needs to go to Dr. McKenzie Monday the 16th at 1:50 for his pre-op to make it okay for his general anesthesia. The process at Coral is that you go to the front desk by 1:20 and that you tell him that you're getting him to the doctor's appointment. His surgery is on the 20th. It's going to take 6 hours, and one of us will have to be there at all times. If you're not going to be there, let me know so that I can take the day off. If you are going to be there, I will probably only be there for parts of it so that I don't miss too many UNR classes. So basically, I'm telling her, hey, let me know if you're going to be there, because if you are, I'm going to, partially be there. If you aren't, I'll just take the day off and I'll be there the whole time. And then I'm also mentioning, I'm not saying, hey, I'm going to just take him. I'm saying, hey, here, there's an opportunity for you to take him. And then I think that's everything. Let's go to the next section here. Okay, so this is like a long-winded response. She says that she has something important at the school tomorrow. Okay, we've talked about this before. You see how they communicate vaguely like this? What's the important thing? She's not going to tell me. You know what? Actually, I went through this email before, so I'm going to go ahead and move back up to the next one. I would, of course, much rather do it January, but his teeth have massive issues. Yeah, I went over this before too. Let's go ahead and move on. And here she's saying, don't threaten me. I can't afford a procedure that's not covered by insurance. She can't make money appear out of thin air. Her insurance doesn't feel like it's a needed procedure. Neither does she. I love this statement here, that her insurance doesn't feel it's needed. That's just lovely. Guys, there is probably a grain of truth to that. What she probably did was she probably called the insurance and told them over the phone, our son is not in pain and dad is trying to take him to blah, blah, blah. And then her insurance said, well, if he's not in pain and everything's fine, then of course it's not covered. And so she said, okay, thanks. That's what I wanted to hear. And then she replied to me in this email. This is the weird way that they sort of operate, that she isn't technically lying, because what she did was she told the insurance something that's not true to engineer a response from them that would fit her narration. We're kind of getting a glimpse into the way that they think and operate. Yeah, let's go ahead and move on. Exhibit 5. Okay, I couldn't wait. Okay, so this is from her to Barry Blue, which is the paralegal, I think. She's telling him that she couldn't have taken any earlier day off from work. That was the early. Okay, wait. Are we starting from the bottom? Where is the bottom? Here we go. Our son's good. 2 teeth were extracted, several crowns on others. Okay, so this is after the procedure. I'm letting my ex know that Army's doing well. Here's another communication from my ex saying, did he get prescriptions? And then here's my response. No prescriptions. He should be 100% by the time he gets back to you. He's doing fine. My ex says, really? She's had dental surgery and it took her weeks. Is he in pain today? What doses of meds? Blah, blah, blah. By the way, guys, I mentioned that this nutty response from her actually comes up in court, and the witness, which is the expert witness, which is the dentist, takes the stand and tells the court, looks the judge in the eye and says, no, he was fine. This is not something that takes weeks and weeks. So you're going to get to see that when we actually get to the hearing video. Then I'm telling my ex that he's on Motrin, child's Motrin actually. Takes 1 today. He's basically recovered already, etc., etc. And then my ex says, whatever, stop trying to go to me. Stop trying to go to people's houses. Never going to happen. Nice attitude. Anyway, it just continues to prove why her parental rights get terminated. Next assertion here is, couldn't have taken any day off from work. And she's telling the lawyer that I tried to get her to go to someone's house. So maybe it's somebody else's house that she's talking about. I'm not sure what that's about. Never informed who the sitter was. according to the court order, has to provide. Okay, so this is just something between her and her paralegal. I'm not really sure what this is all. Wait, what? She's trying to get me held in contempt of court. Can we ask to have him held in contempt of court? And so, guys, she never files a motion. So, I mean, but that's the highlight for her. His teeth are falling out of his skull. He has infections, and this is her obsession here, which isn't even true anyway, because I'm sure if it was true, I'm sure that the lawyer would try to hold me, or try to hold me in contempt of court. I almost said that the lawyer would have held me in contempt of court. They can't do that. They have to ask and get the judge to do it. But in any event, I'm sure if this was true, they would have filed some kind of motion, but she doesn't file anything. All right, next section. When did you end up going? Okay, starting from the bottom again. The directions given for the surgery are Mount Rose Highway, St. Mary's Urgent Care Building. This is an email from my ex to me saying that I still haven't given her a time and that I'm required to provide the address and phone number. Wow. You didn't know how to use Google. Okay. I'm sure this isn't true anyway. I'm pretty sure she was given the address, but in any event, here's the address. So here's the address given to her from me. Going to the next section. So she says, why didn't I have Robbie text her so that she could be there? This is even more confusing. So just a bunch of questions here. Next assertion is that it's 11. Okay, so she thinks she missed it. So she's not even paying attention. So she's trying to say, hey, I missed the appointment. Why didn't you give me this information? Here's a bunch of questions that she's giving me. And then here's my response. You didn't miss it. It's at 11 o'clock on Friday. And then she says, when did you end up going to do his pre-op? Yes. She is not happy that I was able to get around her. So this was the pre-op that I did with the doctor when he found out that my ex interfered with my ability to take him. Really awesome guy, Dr. Jason McKenzie. He just said, you know what, when you pick him up, just bring him in. I'll make it work. And he made it work. I'm sure she got notice of this from me. She's acting like she didn't, but whatever. I mean, this is not an issue because I don't remember it coming up at the hearing anyway. If something isn't filed by my ex, I really don't know what she's talking about because I can't remember because she brought up so many nonsensical things that it's hard to remember any of them at all. The ones that I do remember are the ones that ended up either in a hearing or somehow in some kind of paperwork that she filed. So this assertion that she didn't get notice of the pre-op, I doubt it's true. Exhibit 7, order after hearing, which we already went over in the My Docket series. I'm going to move on. Exhibit 8. What is this here? Another email. Just a reminder. It looks like my ex is sending this to me, that she's going on a vacation to her cousin's wedding in Washington, and that she's going to stay at a campground most of the time with no signal or internet. And then I just said, thanks for letting me know. Exhibit 9, we have another order, which we've already gone through, and that's the end of that. Going into the aftermath, I didn't file anything, so I incurred $0 in costs. My ex's attorney filed the opposition, and she incurred $25 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. It was a pretty lengthy opposition. There was quite a bit of detail to it. It wasn't super long, but at the same time, it did not look like a copy and paste. It looked like she put some work into that document, and I also noticed quite a few exhibits, which again, not really a lot of work. That's just kind of sticking him at the back of the document. I almost said 2 hours, but I think it would be more reasonable to say an hour and a half, given the fact that the paralegal would have helped a lot. So I think under the circumstances, 1 hour and a half in attorney fees for my ex is reasonable, which is going to come to, at the rate of $250 an hour, $375 in attorney fees for my ex. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.